right, thank you for coming back from the break for another session. I'm Tony Puckett. I'm here with Kristin Simpson. We're going to talk with you about a topic that fits right into the general theme of this seminar this time. It's being in compliance and out of court. And the specific topic is workplace investigations. I think it's a very important topic for employers or HR professionals to know about because it is key to keeping you out of court and in compliance with the laws. It's also a recurring issue for employers, so hopefully what we say today will be a refresher for all of you because you've done workplace investigations before. And if you have done these, you know it's one of the fun things you get to do, right? Because you get to play the detective. It's your CSI moment that you get to have in your workplace. The investigation, seriously, is one of the first steps in dealing with any employee complaint or concern about harassment, discrimination, failure by your company or your business to follow laws of any sort, particularly in the employment area. And the thorough investigation is critical. It's key for how you deal with not only that complaint, but it also sets up your defense for later litigation by the employee, whether that's a claim with the EEOC or a lawsuit in court. And conversely, a poor investigation leaves you open to greater chances of having liability found against your company. Why do an investigation in the first place? When may it be necessary? Well, obviously, if an employee comes and complains and says, my supervisor has been harassing me by saying these things about my weight, about the color of my skin, about my past veteran status, that's an easy one. You know that's a complaint that you have to investigate. But employees often are more subtle in how they talk to you as HR professionals or talk to their supervisors, and they can say, I'm kind of concerned about this, or they might not even use some other employee and say, my coworker is concerned about this. Or everybody's favorite, it's an anonymous complaint, something slid under your desk, or slid under your door rather, for you to see when you come in the next morning. Or my personal favorite is, I want to tell you about something, but I don't want you to do anything about it. Okay? Should you investigate? Hands up. Yes, you should investigate. You also need to do an investigation when management becomes aware that a law or a company policy may have been broken. And you may think you know that that has occurred, how that's occurred, but you still need to do the investigation to gather the facts and document what exactly has occurred, so then you know what action to take after that. Another time an investigation may be necessary if you have an employee whose morale has changed significantly or has become a behavior problem or performance problem in the workplace. There may be something going on with that employee separate from just a lack of motivation. There may be some issue in the workplace that's causing the employee not to want to be there, not to want to work as hard. So an investigation can be helpful to get to the bottom of that. Why perform an investigation? This builds on the last slide. Well, you want to gather facts to make an appropriate employment decision. I often talk to my clients anyway about what does the data show? What do the facts show before you make a decision? Do you know what the facts are before you make a decision? An investigation helps you avoid the situation where the supervisor says, I know what was wrong, and here's what's wrong, and here's who did it, and here's what we're going to do about it. Because I'll tell you, about 8 times out of 10, that supervisor will not have all the facts and won't know exactly what happened. You need an investigation to help you gather those facts to make appropriate employment decisions. You also may need to perform an investigation as a self-monitoring tool to ensure that you are complying with policies, employment laws, and company policies. This is a little bit of a byproduct of just doing the investigation itself. It gives you a peek into that department or that work area to see if they are following your other policies as well as the ones about which the employees made the complaint. Another reason to perform an investigation, it minimizes the risk of disciplining or terminating an employee for something the employee might not have done. If I get disciplined for something I don't think I did, is that going to create a morale issue for me? Yes. It's going to create a morale issue potentially in that whole department or for that supervisor. So again, you want to have the facts before you discipline employees. Oftentimes, an investigation also can uncover hidden problems. You'll investigate the complaint, the specific issue, but by doing that, often you find other issues in that department. It may be an issue with your policy, whether your policy really speaks to what's going on or what you need to have happen in the workplace. And very often it uncovers some other issues, what I put in the supervisory category. Is the supervisor doing everything the way he or she really should, or as well as you think the person can do his supervisory responsibilities or role? And so there may be some areas for some coaching of the supervisor, separate from the discipline that might come out of the investigation itself. And then, of course, a legal reason to do an investigation is to provide an affirmative defense, particularly in claims of harassment or discrimination, if your company is sued later. And this affirmative defense Often gets called by us lawyers the Farragher-Ellerith defense out of a couple of Supreme Court cases, United States Supreme Court cases from 1998. And those cases said that every employer needs to have an effective policy prohibiting harassment and discrimination, and that you have to take appropriate remedial action if you find there's been a violation of your policy and there's been harassment or discrimination. What makes a policy effective? Is it having it in a nice book and having that up on the shelf in your office? No. Is it having it on your website where employees, if they want to click through all the pages on your website, can go and find that policy and read it? No. What makes it effective, and this is what the courts have said, is whether you enforce that policy. And the way you do that, the way you bring it to life for your employees, is by responding to their complaints and doing an investigation. The investigation is critical here for you establishing this affirmative defense so that you can defend a lawsuit that you may get. Now, some investigation considerations, and this talks about some of the issues to think about before you start the investigation, and Kristin's going to go in more detail on the steps of the investigation. Do you have a policy on investigations? If so, what does it say? Before you start the investigation, it's a good idea to read the policy. That doesn't happen a lot of times. In fact, I'm in the middle of an arbitration where I'm not sure my investigator read the company policy before he started down that path. That creates issues for you later on, obviously, if you don't follow your own policy. Other investigation considerations, can you identify the policies potentially violated? I mean, what are we looking at in the investigation? Another consideration is who should be the investigator. Is it someone internally in your organization, or is it someone externally? And some of the considerations for that are, do you have someone trained on doing employment investigations? This subject can be the subject of an entire day's training, and you may want to consider sending someone from your organization to get that sort of training so that you can say, yes, we had a trained, competent person to do the investigation. If you don't have somebody trained internally to do it, you may want to seek an external person. There are lots of HR consultants who used to be in your shoes or now are doing consulting that can do investigations. Another reason for an external investigator, sometimes you just need someone for whom there's a perception of greater objectivity, someone who doesn't know all the players, if you will, doesn't have any biases against the employee or not perceived as having biases against the employees interviewed in the investigation. You also have to consider the breadth and formality of investigation. A lot of what we talk about sounds like a very thorough, a very formal investigation, and that's true. We like to see that often. It helps us do our job. But sometimes you can deal with these issues with a more informal inquiry, checking with the employee, making some notes about what occurred, and getting back to the employee before you launch into that in-depth investigation. Another consideration, whether to record interviews or not, or whether to get written statements from employees. There are a lot of pros and cons about recording interviews. One of the biggest is it can really chill what an employee is willing to say. It can really dampen their willingness to tell you what they know and what you need to hear. So most of the time I don't favor recording interviews in investigations. There are some even policies that require it. I do think it's important to get some sort of written statement from employees besides just having the investigator's notes about what was said. That can be a statement where the employee writes out and signs. You can do it through email to capture what the employee said and confirm with them. Other considerations, notice to the employee. There's your policy one, say you have to give notice during a certain period of time. If not, when is the timing of that notice you provide, particularly to the employee who's the subject of the investigation. Then, of course, the time frame for doing the investigation. You heard earlier from one of our other attorneys to do it immediately, and that is the best thing, to do it as quickly as possible. There are often times, though, where you need to get your ducks in a row, so to speak, before you get started, so you can get it completed quickly and how to have it drag on. And then administrative leave, the issue there is should the employee against whom the complaint is being made, the person you're investigating, should that person be put on administrative leave to remove that person from the workplace during the investigation? I'm going to turn it over to Kristin now for the next few slides.
Good morning. So as Tony talked about, one of the things we want to talk about is your applicable policies and procedures that you have in place. And you need to talk, that will usually tell you who needs to be notified, is authorization required from any sort of manager before you conduct an investigation. Does senior management need to be present in the interviews? This is all something that you need to figure out right at the beginning of your investigation. You should gather your relevant documentation about the employees. This includes personnel files, emails that might have transpired back and forth between employees, any sort of performance reviews, disciplinary records. If there was a previous investigation that involved the employees at issue, you should gather those as well, just so that you're not surprised by any documents to the extent that you can do that. If you think that the employee needs to be notified who's being investigated, you should do this at that point. Consider whether there are going to be issues of the employee destroying evidence or the employee getting in the way of your investigation. And if you have any concerns about that, I wouldn't notify the employee at that point. Then you have to round up who might be your witnesses in this case. So who works with the employees on a day-to-day basis? Who might have actually seen the offensive conduct that occurred? Is there somebody who supervises the employee? Is there somebody that the employee is friends with that they might have confided in? These are the types of questions that you need to ask to make sure that you're talking to everybody that you need to talk to. And then after you've interviewed those witnesses, internal and external, then you're going to want to talk to the employee who is under the investigation. You need to let them tell their side of the story. It's important that they get this chance to share with you what might have happened, because it could be as simple as a misunderstanding or as simple as a personality conflict, or it could be something more problematic like harassment that definitely needs to be taken care of. Once you've gone through all of these steps, you're going to review all of your materials and draft your report. And I'm going to talk about drafting your report and reviewing the materials in a little bit. Getting into the meat of the witness interviews, because that's what's going to be most important in this investigation. You're going to want to take notes. In some witness interviews, you'll have two people that are doing the interview. One person, you should designate them as the primary question taker, and the other person should be somebody who is taking the notes. The question taker doesn't need to not take notes, but that way they can focus on the witness, they can have a rapport with the witness, and put the witness at ease so that things are better for them to give you the truth and that you're getting the best answers from them. Once you start the meeting, you need to give them the general gist of why you're taking time out of their day. Tell them that there's a general complaint that they're investigating, but don't give them too many specifics. The whole point of this meeting, when you're interviewing this witness, is to get them to tell you what they know. You don't want to be telling them what you know. That removes the advantage that you're doing in conducting the investigation. You need to let the employee know your expectations. At the very beginning of the interview, impress upon the employee that it's important for them to tell you the truth and give you full, honest answers. You need to tell them that they will not be retaliated against if they participate in this interview and they give you full, honest answers. But there is a problem that if they are untruthful, or if they give you partial truths, or if they're lying, or just general dishonesty, that they can be disciplined or even terminated. You should generally start out with easy, simple questions. You want to build up that rapport with that witness so that they're at ease when it comes time to ask those uncomfortable questions later. You might want to start out with asking about the general atmosphere in your work group, or find out what type of communication styles are at issue in this case. Or if you're interviewing subordinates, find out what type of management style the supervisor has. And by asking these sort of general questions, you'll find out if there's any problems that you're unaware of, and just get a general feel for what's going on in that work group. After you've asked these general questions, you should delve more deeply into the specific reason why you're conducting the interview. Once you've built up that rapport with the witness, go ahead and go into the tougher, more unpleasant questions, because everybody knows you don't want to just jump in. Hi, thanks for coming today. Now, please tell me about that time when you were in the bathroom and you heard somebody say the N-word. That's just not a good way to get the answer to your questions. So once you get into the specific questions, see if they've witnessed any inappropriate behavior, see if anybody has complained to them about this specific instance at issue. Find out, for example, you could ask if offensive jokes or comments have been made about anybody in the group. You want to continue asking your questions until you feel like you've gotten all the information that that witness knows. If you feel like the witness is being evasive or they're giving you partial truths, then get more specific in your questions. But you have to be careful to not ask any confrontational or accusatory questions. You don't want the person that you're interviewing to feel like they're on trial. You don't want them to feel like they've done anything wrong. That's not the purpose of these witness interviews. Discipline will be, if necessary, will be handled down the line. You're not doing that right now. This is just a fact-finding mission and nothing else. So keep it light, but definitely ask those pointed questions if necessary. Once you're done with your general questions and you feel like and your specific questions, and you've gotten everything that you can out of the witness, It's important to conclude the interview to tell them what happened, give them a summary of what to expect going forwards. Make sure you ask the interviewee if they know any other information that may be relevant to the investigation. Sometimes there's just something that you didn't think to ask, but they know, and that question gives them an opportunity to share it with you. You should ask them if they know of any other witnesses. Most of the time, you'll already know who those are from whenever you've previously reviewed everything, but sometimes you might not. They, being on the ground, have more information, and they deal with everybody on a day-to-day basis, so it's important to do that. Ask the interviewee if they find out anything new that they should come to you. Sometimes after sitting, going to sleep at night on something that they haven't thought about for a little bit, a memory will pop up and they have new information they can share with you. The next one's really important, and this goes back to what Josh and Natalie talked about. Let them know that they should not be retaliated against by anyone. This includes coworkers, supervisors, anybody at all for talking to you in this investigation. Let them know that it's important to tell you immediately that retaliation has occurred and that your office door is always open for that. And then finally, if you have concerns about witness tampering or a certain confidentiality situation, let the employee know that you would appreciate their discretion and to only talk about the investigation on those who have a need-to-know basis. Now, we talked a little bit about this as far as crafting your investigation questions, but you want to make sure that you're getting the who, what, where, when, and why. That's really the big deal with these investigations. It's also important that you're getting the timeline of any events, especially if there are issues as to he said, she said, or something like that, that you get chronologically what happened from start to finish. See what your employee's explanations are. If you're talking to the person who's been accused of wrongdoing and they say that the person who accused them is lying, find out why they think that. That's an important factor, because if it turns out that these people used to be dating, for example, and now they've broken up, and now there's this workplace harassment against somebody, that's important for you to know. So find out reasons why somebody might be, why they might have the explanation they do for the event. Next one's also pretty important, that when you're doing these witness interviews, see if you can get corroborating facts from the different witnesses. Craft your questions so that you can determine, yes, these three witnesses all have the exact same story, and that's pretty good going forward, that this is what happened if these people all said the same thing. And then also, when you're doing these witness interviews, make sure you craft your questions so that you're getting any documents or photos, emails, letters, pictures that might have been posted somewhere that you just aren't aware of, that you didn't find in your previous search while you were getting ready. And then finally, make sure that you are asking for a written statement. Tony touched on this a little bit ago. This is important that you have what happened in the employee's own words, preferably signed and dated by the employee, but an email exchange is also sufficient. Then finally, once you've done all of this investigation, you're going to need to put it down in writing. Now, we titled this slide Investigation Report. And certainly at times you will have a full-blown investigation report. However, sometimes it's just sufficient to put a note in an employee's file, talk to Sue about her complaints. She feels like they've been resolved, and that's sufficient. Now, other times it's important that you do a full-blown report that is a full summary of everything that you learned in your investigation. Put it in chronological order just so that it's easy to read. Make sure that you're doing a fair summary of your witness interviews. When possible, when you're taking those notes during the witness interviews, put quotations around things, especially ones that are of particular importance to your investigation. Offer credibility assessments of your witness. If it appears that your witness was not telling the truth about something, make a note of that, but just because it's important for somebody reading the report to get those impressions if they weren't the ones doing the investigation. Be as detailed as possible to the dates, the times, the facts, all of those things. Don't express opinion about discipline, though. That's important. That's, again, not the purpose of why the investigation was being performed. The investigation is a fact-finding mission, and then should the investigation lead to the need for discipline, then that would be decided later. Remember that this report possibly will end up in litigation. Obviously, the goal of doing the investigations is to keep your employees happy and to take care of problems before they get too big and the employee feels like they don't have any other choice. But remember, when you're preparing your report, prepare it so that it will be Exhibit A in any lawsuit that gets filed. Obviously, that's not what you want to happen, but if you have that exhibit, You have the investigation report for later on. It'll be proof that you properly conducted that investigation, and it'll give you the good faith legal defense. And I'm going to pass it back over to Tony now to talk about what to do with the investigation once it's done.
This is the hard part, if you will, applying the investigation to your discipline decisions. And the first part of the slide says, consider all aspects of the investigation. What do we mean by that? I mean, what do the facts from the investigation show? Not what do you think they show, what were you hoping they would show, what does the supervisor still believe happened, but what do the facts show themselves? Because later on, we're going to be asking you to use this report to prove the reasons for the discipline you decided to take. You have to look at what the investigation actually shows. Do we have objective facts, things that nobody really can argue about because it's recorded, for example, on video or because it's part of a Facebook post? An investigation I have right now, it's actually discipline we're dealing with through an arbitration, is all of the evidence of the misconduct was either captured on video or as a Facebook post by the employee who was terminated. That's the rare situation, but we have all the evidence there that we need. If you don't have those objective facts, you have corroborated stories. The complainant, what the complainant said happened. Are there witnesses who corroborate either all or parts of that story so that then the complainant's allegations appear to be credible, appear to be truthful? If you don't have that, you have the he said, she said situation, or she said, he said, or a bunch of people said this and a bunch of people said that, and it's hard to figure out exactly what happened. You don't necessarily have to make a credibility determination in that situation, but you want to look at the report and determine, is that the situation before you make your discipline decision. Another thing that's important to consider is the bias of any witness, either the complainant or the person who's being complained upon, so that you take that into account. Is there a reason the person made the complaint, for example? What's the backstory, if you will? Is there history between the employees before you say, yeah, we're going to sign up, we're going to support what the complainant said, hook, line, and sinker, and fire the employee that she's complaining about? Another consideration for you is to consider the employee's history with the organization. Usually that is the employee who's the subject of the complaint, the person who may be disciplined. And you want to do this for every employee that you're considering discipline for, so that you can say later on to a jury, yes, we considered, and you can say it in your deposition when you're being questioned, we considered all of that employee's history with us, including performance appraisals, commendations, write-ups, length of service. Is it a 20-year employee and this is the first time the employee's been in trouble? That might weigh into your discipline decision. Of course, what do the performance evaluations say? Because performance evaluations given over a series of years can be inconsistent with what is now being said about the employee. And then is there any disciplinary history for the employee as the employee started down that progressive discipline path already before you got to this issue with the employee? Some other issues to talk about in terms of applying the investigation to discipline decisions. Everything on this slide, at least the first 3 bullet points, talk about consistency. Are you being consistent in what you're doing? To check that, there's a number of different aspects to it. You look at similar offenses by other employees. If this is a sexual harassment complaint, have you had other complaints of sexual harassment by other employees or against other employees? If so, what have you done in those situations? You also consider discipline for similar offenses. If you found it was sexual harassment and it's one of the quid pro quo, one of the more serious types where someone wants to trade a sexual favor for a benefit at work or retaining a job, what have you done in similar situations that you've had? Have you terminated employees for that? Next one, consider other incidents with same discipline being considered for this matter. This is looking at it in the reverse manner. Look at who have you terminated and what have you terminated those employees for? Does this issue with this employee fit in the seriousness of that same sort of category as the people that you've terminated? And then lastly, consult with management, other management who aren't involved in the investigation or with the employees or with your counsel. And this is a double check. This is a check to say, are we looking at this investigation report, the facts that we think we know from the investigation in the right way? Are there things we've missed? Is there some other consideration we should look at, some other information we should gather before we make a discipline decision? That's always a good step because you get in the investigation, you can get very close to it, and you want to have somebody who's a little bit distant to it look at it and give you some advice at that point. It's also key at that point to make sure you have considered retaliation as our last segment, the speakers in our last segment talked about. We're at the end of our time. Thank you for your attention. I'm going to introduce our next speaker, Mike Lauderdale, to talk about avoiding litigation after an employee leaves.
Thanks, Tony. All right, just a couple of preliminary matters. First off, for those of you, and I know who you are, that text me during my presentation to make fun of me so I see it afterwards. Lawyers are people too. We have feelings just like human resources people. So think about that before being too mean. And we spent most of the morning talking about how do you not get sued? How do you avoid litigation? Well, selfishly, from both our standpoints, getting sued every once in a while is job security. So don't be too good. Really, you can do everything by the book and you're still going to get sued. And we all have to understand that. It's just going to happen sometimes. But what we're learning today and what we want to finish up with, really in my mind, is a critical way to avoid that ultimate EEOC charge, the letter from the lawyer, and it's real simple stuff. And we're going to go through some of this, and you're going to be like, why are we paying to come to this? Oh, wait, you're not paying to come to this. You really are, you just don't realize it. So, a lot of this is very simple, but it's where I see employers making the biggest mistakes. And it all starts with, all right, we're going to terminate the employee. And I hate the word termination, and some of you have heard me say this. I like saying separation. It's kinder, or we're going to transition you to better opportunities. Saying fired, terminated, you get the letter from the plaintiff's lawyer, you fired my client. Well, no, we just separated her. Better thing. So really, words matter. So you get to the termination meeting. Again, simple stuff. Don't embarrass the employee. And that's why timing's of the essence. That's why we have separation meetings on Friday afternoon. That's why we wait till the end of the day. Don't perp walk the employee out of your facility. And we have to do that sometimes. We have to get access to the IT information. We can't let the employee take confidential information with them. We don't want to return the employee to the workplace. So really think it through, plan it out, pick the best time. It could be in the morning, it could be in the afternoon. You have to decide, how are we going to get the employee's personal effects? Work through all those issues ahead of time. Do we need car keys? Do we need credit cards? Do we need key fobs? Think all that through and plan it out, because if you don't, it can blow up on you, and what could end up being a smooth separation makes the employee mad. They're already going to be upset, obviously. Feelings are going to be hurt, but we have to plan that termination meeting out. A couple of other things. We're not going to get into a discussion or argument during the separation meeting. And just like if any of us were being separated, we're going to want to know why. So you're going to have to give some information. But we need to keep it general, and we're not going to drill down, because it's just human nature. I'm going to want to know why. I want to get a chance to talk about it. We need to make it clear, and you need to make it clear, once you have that meeting, the decision is made. If you're not sure you're going to let the employee go, we're not going to have a termination meeting. We're going to do other things ahead of that. But once you decide that trigger is going to be pulled, you have to tell the employee that. And you may have to repeat it time after time. We're not here to argue. We're not here for a discussion. The decision's been made. Let's move on and talk about other issues. You also need to decide whether or not we're going to be doing certain things. Are we going to contest their unemployment? And we're going to talk about some new unemployment laws in Oklahoma that make it much easier for you as an employer to claim misconduct and stop an employee from getting benefits. And especially, well, for all employers, but really for your smaller, mid-sized companies, Unemployment insurance is important, and you give up on a claim and your rates start going up and you get yelled at and we get yelled at, so we have to watch it. But I have seen more litigation arise from contesting unemployment as a matter of reflex than it wouldn't have if we'd have gone ahead and given the benefits. Because if you contest that claim for unemployment and you win at that initial stage, as we all know, the employee gets appeal rights. And that is many times when they go talk to a lawyer. And when they go talk to a lawyer, you may still end up winning the unemployment, but the lawyer starts drilling down. FLSA claims, retaliation claims, all those things can arise out of a decision to not or to contest unemployment. And you'll hear me say many times, yeah, you could probably win this, especially under the new law that we're going to talk about, but is it really something you want to do? And letting the employee collect their unemployment benefits and move on can provide some benefits later. So talk that through, make a decision. Is there any work comp issues out there that we have to deal with? Have to think about that. We'll talk about that a little bit later. Severance agreements are a big issue in release. If we can get a severance agreement, even though sometimes the people that you report to kick at that, it's well worth it in the long run. And Josh, here in a few minutes, is going to talk about some of the key issues on severance agreement. And if we've got a prior EEOC charge, or if we know there's litigation demands out there, that plays into consideration also. And you've kind of heard people talking about retaliation and investigation, so we won't spend too much time on that. So I'm going to turn it over to Josh. Josh is one of our new associates, and he and I work together on employment matters, and you may see him if you work with me, but he's going to talk about severance agreements.
Thanks, Mike. And as Mike said, one of the ways to avoid litigation is to have the former employee enter into a severance agreement and release. So the question is, when is it appropriate to offer a severance agreement? Well, in terms of time, it's appropriate to offer it as early as the termination meeting or the separation meeting, if you prefer that term. But the key is to discuss it generally in that meeting and not provide the legal document to the employee at that time. As we said, it can be an emotionally charged atmosphere for the now former employee, and it's better off to give them some time to relax, some time to think about it. And since you're going to be doing it on a Friday, send it to them so it arrives on Monday or Tuesday of the next week so they can look at it with a clear mind. Now, whether you want to offer a severance agreement in the first place depends on an analysis of your exposure. You need to make a decision before the termination meeting or shortly after whether you think you feel comfortable with the decision you made and whether you feel that there was a clean break. Or on the other hand, if you feel like this is an employee who could cause trouble afterward. And so if you have an exposure, then you need to make sure that they accept the offer if that's what you're going to do. And to reduce that risk, what can you do? It's all about the Benjamins. It's all about how much money you're putting in front of them. And there's 3 simple rules to determine whether it will be accepted. And really, it's whether you're giving them a little bit of money, a decent amount of money, or quite a bit of money. And if we're talking about a severance agreement that's a month or less, we're talking about a severance agreement that will not be accepted by the employee. And it's certainly not enough money to make it worth their while. If we're talking about 2 to 3 months worth of salary, it's an agreement that may be accepted, but you're putting yourself out there that they may not accept it, and now you've raised the awareness in the employee's eyes that they may have a claim that they hadn't thought about. You've waved the red flag in their face, and now they may take some action if they don't accept it. If you're talking about a severance agreement of 6 months of salary or more, that's something that the employee is going to take almost every time, and you've reduced your risk. Now, what are some key terms of the severance agreement? The first one is consideration, and that's a fancy word for giving the employee something that they would not have otherwise been entitled to. So you can't tell them in exchange for this release, we're going to give you your last paycheck for the time you've already worked. They're already entitled to that. So you have to give them the money that we talked about earlier. The next thing is a release of claims, and not just the claims that you think they may bring, but a release of all claims that they could possibly bring against the employer. Confidentiality and non-disparagement agreements, these sometimes are difficult to enforce, but at least you put it in front of the employee. You shouldn't be talking about how much money you've gotten, and you shouldn't be bad-mouthing the employer. And and then finally, there are some certain mandatory terms if the employee is 40 or older. The Older Worker Benefits Protection Act requires certain language be in there to release age claims, and so it's important to make sure you're in compliance with that act. And now to talk a little bit more about unemployment, Mike will be back.
All right, thanks, Josh. All right, let's circle back around and let's start talking about this unemployment issue. And as I mentioned earlier, an unemployment claim gone bad can cause you and me and all of us more problems in litigation that could have been prevented with some very simple, basic rules. Number one, as we just talked about, do we even contest it? You've got to make that decision up front, and that can be part of your discussion in the separation meeting. If the employee asks, are you going to contest my unemployment? We're going to know the answer to it. And if it's tied in with a severance agreement, the answer is, if we can agree on a severance agreement, we're not going to contest your unemployment. Now, you can't release a claim for unemployment. In fact, it's a criminal violation to try to do so. I learned that the hard way about 15 years ago. And so be careful and not mixing those two issues. But that's decision number one. Now, our Republican-based legislature has been very diligent on attempting to fix some of the issues that we've seen at the Oklahoma Employment Security Commission regarding claims for unemployment. And so last year, there's a new definition of misconduct, and it's very broad. You'll see unexplained absenteeism or tardiness, willful or wanton indifference, willful breach of any duty, mismanagement of a position, pretty broad, acts or omissions that place in jeopardy the health, life, or property of others, dishonesty, wrongdoing, again, very broad, violation of a law, not too broad, but you can make some argument there. And then finally, the very, very broad definition, a violation of a policy or rule adopted to ensure orderly work or the safety of self or others. Big hole to defeat a claim for unemployment under these definitions. Now, practically speaking, we are not seeing the OESC take that rule into serious consideration. They are still relying on this willfulness or intentional standard. But if you are in one of these hearings and are paying attention, you need to understand the definition, because the administrative law judges will look at the law and hopefully follow it. In response to these issues, there's a new Senate bill that is likely going to be passed that redefines the definition of misconduct. And it is undergoing changes as we speak, so my slides aren't exactly up to date. I was at the Capitol last week trying to figure out some compromises. But under this new definition, when it comes out, you'll get an email from us that talks about it. But it is going to clearly define what is misconduct. So in our opinion, the OESC will be stuck with that definition. And it's the same type of issues, except you're not going to see any willful or wanton language. It's going to be more open-ended, primarily based upon the Texas definition. I know we don't like being like Texas, but that's kind of our goal, in that if an employee does do something wrong and deserves to be terminated for cause, and we've done the right things along the way, the employee is not going to be entitled to unemployment. Some of these have changed a little bit, and my best advice now is to wait to see what the bill says, and it'll be effective in November, and you'll get a blurb from us on that, the email that I talked about. If you're using a third party to handle your unemployment claims, which we're going to talk a little bit about in detail in a second, make sure they're aware of this new definition. Now, some of the other changes is that You can send in an affidavit now. You can send in evidence to demonstrate the misconduct, and then the burden shifts to the employee. We're not seeing the administrative law judges follow this, so it needs to be pointed out to them. And the second big issue I want to talk about is, okay, we've decided to object. We've won or lost at the initial determination level, and then we end up at a hearing. And here's where I see the biggest problems that hurt us later in litigation. Most of the time, we don't get involved in these hearings unless we are concerned or aware that the employee is going to bring a claim. And that's rare because it really is just too expensive for you to hire us on most occasions to handle the unemployment hearing. So you will show up at one of these, or your third party will show up at one of these, and the employee will have a lawyer. And so if you have any hint or inclination that you're going to be sued, you better get prepared for that hearing. Because even though under law, that order that the ALJ issued is inadmissible, everything leading up to it is admissible. Everything's going to be taken under oath. All the evidence, all the exhibits will eventually be discovered in the litigation. And it will burn you if you're not careful. I can't tell you how many times that we've got a claim come in and then we go back and look at the unemployment file, because that's one of the first things I'm going to ask you about. And the reason that we proffer at the unemployment hearing is different than the real reason. And a lot of the hang-up comes in through the use of our third-party claims processor, who never really has a good handle on why we terminated the employee. And once that happens, we've got problems, because the plaintiff's attorney is going to cross us up and give us a tremendous amount of difficulty as to why we testified under oath, including our agent, the third-party processor, that we terminated this employee for absenteeism, and it was really because they got in a fight with their supervisor. And once that credibility issue comes up, we're never going to get summary judgment, and we're going to look bad. So prepare for the hearing. Make sure you have the right people there to testify. Many times you'll have a good enough reason to defeat it, but we won't have anyone there with personal knowledge, and the ALJs or hearing officers will bust you on that immediately. And then make sure we have the right reasons and that we tell the truth. But once you get into that hearing, we have to be aware. We've talked about, should we even appeal? Another issue that I want to talk about today is work comp. And I want to focus on one specific issue. Now, there are major changes going on with work comp that I know you know about. And we're already seeing them happen. Starting February 1st, there's a new work comp commission. We met with and talked to a couple of the commissioners the other day to kind of see what was going on. One of the commissioners is one of our former law partners, Bob Gilland. And they're gearing up and they're going and they're hiring their own hearing officers, and it's going to be a whole new world out there. And these work comp retaliation claims that scare us to death are now going to be heard out at the commission instead of in court. But that doesn't mean you still don't have to be careful, because even though we're not in front of a jury anymore, if we terminated someone for filing a work comp claim, we're going to get burned in front of one of those hearing officers. Now, the damages are capped at $100,000, but it's still a lot of money. But the way to make sure that this doesn't happen in the first place is to be active with your work comp, either insurance carrier or attorney, when it comes to resolving the workers' comp claim. Now, in my opinion, the reason we got to the problems that we had with our work comp system is that every time an employee was injured, whether it was major or not, the work comp attorney took the position that it was a permanent injury. And they would send the employee to their doctors, and even if it wasn't a permanent injury, at least in my mind, there would be one. Because if there's a permanent injury, what does that mean for the employee? What does he or she get? Money. And the attorney gets a portion of that money. So every injury out there was permanent disability. And when you go in front of the work comp judge, usually there's no dispute that the injury occurred, so some money gets apportioned. You're still going to have a lot of those claims out there because there's still thousands of claims pre-February 1, and even if it's not, you're still going to see these claims for some permanent injury. Be involved in the negotiation process with your carrier or attorney. If there's a dispute as to the extent of the injury, which there always is, when you're negotiating that settlement, negotiate a resignation and a release. Now, it's easy for me to get up here and say to do. Your work comp lawyers may fight you on that. You may hear them saying that, well, that's really bad faith and we can't do that. Well, it's not the case. I've seen it. I've done it. It is permissible to sit down with the opposing lawyer and say, if you want to settle this case, part of it is you're telling us your client is so injured he or she can't work. Let's go ahead and resign. Because as we all know, you'll get paid on this 40% permanent injury, and then they're ready to go back to work the next day. It's amazing. It's a miracle. But the work comp court doesn't care about that, but you should. And so you sit down with the lawyer and you say, look, you say you can't work. This is a gimme. Resign. You can't work anymore. And give us the release. You shouldn't care. You can't work anymore. That will tell you how strong the claim is. But guess what happens most of the time? Work comp lawyer didn't have a problem with that. Employee at the time doesn't have a problem with that because they're getting more money. So get the release. Now, procedurally, just real quickly without bogging you down in the details, you can't get the release from the work comp judge. They have a joint petition and there's a hearing. But as part of that, you have a side agreement to get the release on. Make sure you do that if it's possible. It will save you tons of headaches. And we just kind of talked about that, settling the work comp claim. If the worker does and the employee does come back to work, be careful about terminating that employee, not putting them back in the same job. We've got FMLA considerations. That's a whole other talk. We've got disability considerations. Under Oklahoma law, and this has not changed, if an employee is TTD, temporarily totally disabled, even if they're disabled for 12 years, and I've got some now where the employee has been out for 10 years, you've got to hold their job open for them. It's crazy. It's ridiculous. We tried to get it changed where it's only a year. There's some other provisions in the work comp statute now that I think will fix that, but you just can't let them go for being absent from work. And here's the other kicker. Be careful about terminating their health insurance. There's some language in that law that says you got to keep their health insurance on. Now, they still have to pay their premiums, but before terminating their health insurance, think it through. Make sure you can. Most of the time the answer is no, especially if their FMLA is still going, but that's usually only for 12 weeks. Okay. We don't have a lot of time left, and Josh is going to talk about EEOC charges, but we're getting close to lunch. Real quickly, some things that I see clients not doing. When you have notice of a claim, get your litigation holdout. You'll get burned on that. Law basically said you've got to preserve all information when we have notice of a claim. EEOC charges, as much as it may hurt you to talk about settlement, I love EEOC mediation. It's free. The mediators are good. There's so many benefits. I've never gone to EEOC mediation where I didn't settle, and we settle 70 to 80% of the time for nuisance value, that I haven't learned something new that we didn't know about. It's free discovery. You find out if the employee has an attorney. You at least get an initial demand so you know where the employee is. And every once in a while, I'll walk into one of those and I'll get $100,000, $150,000 demand and we just end it. But most of the time, it's not crazy money. And it's amazing how cases can be settled by saying, I'll get you a check for $500 or $1,000 on Friday. So go through the EEOC mediation process unless you're very confident that you have a slam dunk case. And thank you everyone for coming. We appreciate it.